Greetings, welcome back. This is episode 9, the concluding episode of our journey through the courts and trials process. Today we're going to look at appeals and then look at the idea of wrongful convictions as a way to conclude and try to answer whether or not our system provides justice or just the illusion of justice. So first we're going to look at the right to appeal. This of all our rights is of most recent vintage. Originally, defendants did not have the right to appeal. In fact, they were unable to appeal because whatever the jury decided was the truth of the matter. And there was no place for appeal. No one else was going to look at it. Either you were guilty or you were not. The jury had the final word. It wasn't until later that defendants began to get the opportunity to appeal. Eventually that became included as part of the due process rights. Defendants have the right to appeal. And notice in particular I say defendants have the right to appeal. Just about every criminal appeal is going to come from the defense. Only defendants really have the opportunity to appeal the verdict. If it is a not guilty verdict, the case ends there. The defendant walks out of the back of the courtroom. However, if the defendant is found guilty, then the defendant can appeal. So in other words, the prosecution really doesn't get much of an opportunity to appeal. There'll be one exception to that, which we'll talk about in a minute. Second, in terms of appeals, only defendants who go to trial can appeal. So if you plead guilty, one of the things that you are giving up is your right to appeal. And so if you think about the total number of criminal cases, and we're going to eliminate 90% off the top because they're guilty pleas, and we're going to eliminate another couple percent because of dismissals, things like that, then we have 5% going to trial. Let's say 3% of those are found guilty. At most, only 2% of all criminal cases are going to end up at a point where they can be appealed. So the number of cases that reach the appellate level is rather small. Now, there are some exceptions to whether or not the state can appeal. The state has the opportunity to provide interlocutory appeals. What are these things? Basically, if the judge grants a motion to suppress statements, evidence, identification, the prosecutor can appeal that decision immediately. Because if they go to trial, they don't have the evidence, the person is found not guilty, they're not allowed to appeal. So this provides the state at least an opportunity to appeal if they lose a motion to suppress along the way. Some judges also are going to allow defendants to enter what we call conditional pleas. In these circumstances, the defendants are going to plead guilty on the condition that they can appeal. This is most often going to happen in a motion to suppress evidence. So let's say the defense files a motion to suppress evidence. The court denies the motion to suppress evidence. Rather than going to trial to preserve their appellate rights, the defense may say, Judge, we would like to plead guilty on the condition that we can appeal this motion to suppress outcome. Because the defense cannot do an interlocutory appeal, the judge will allow that entry of a conditional guilty plea. Under those circumstances, the defendant may appeal if the defendant pleads guilty. A second opportunity for the defendant to appeal when the defendant pleads guilty is sentence. Some jurisdictions allow defendants to appeal their sentence. So if they pled not pursuant to an agreement with the state, the judge sentences a person to 5 years, the defendant says no, that's not appropriate, then the defense can appeal that sentence. Those are going to be the exceptions. But again, it's not going to increase the number of appeals very significantly. About 3 out of every 100 criminal cases are going to reach even the immediate appellate stage. In order to appeal, the defense now has to assert grounds for the appeal. There has to be a reason why they're appealing. They can't simply say, I didn't like the outcome, therefore I'm appealing. They have to state legal reasons why that appeal is appropriate. Generally, the first basis that they're going to assert is the trial court made some sort of mistake or some sort of error that led to the defendant either being deprived of the constitutional rights, such as due process, or they were denied in some way a fair trial. And this can take a variety of forms. They can say that certain evidence was improperly admitted. Perhaps the judge allowed hearsay improperly, or perhaps the judge allowed expert testimony that the judge should not have allowed. Conversely, they may say the judge refused to present or admit certain evidence that the defense thought should be presented to the jury. This may be in the form of expert testimony. Sometimes defense may try to present testimony about coerced confessions. At this point, courts have said no, experts on coerced confessions cannot testify in a case. They used to say this about eyewitness identification. They will say this about polygraph evidence, right? Such evidence is not admissible. Defendants can appeal and say, we want that decision overturned. We want to be able to present this particular evidence. The judge may also improperly seat a juror or improperly exclude a juror, and as a result, a new trial needs to occur. Oftentimes, or occasionally, a prosecutor will do something improper during trial, and the judge may allow it. The prosecutor may make an improper argument or ask argumentative questions, and as a result, the trial court has made an error, and the appellate court may reverse it and send it back for a new trial. In addition to these procedural grounds, defendants may find more substantive criminal law grounds. So if you study criminal law, one thing that happens is you read a lot of cases and a lot of appellate opinions. And so what the judges are doing is looking to see, was the evidence sufficient? They're not questioning the facts, however, and this is a very important distinction. The judges are determining only the law. They are not looking at the facts. They're not relitigating the facts. They are not questioning whether the witness was credible or not. Instead, what they are trying to do is determine whether or not the jury's application of law to facts that the jury would have found, in other words, the government's case, as presented, we're going to assume that's true. Was the application of law correct? The appellate court then will say whether that evidence was sufficient as a matter of law. The defense may also argue that the statute doesn't apply to the conduct. This is especially common in criminal cases, where statutes are very broadly worded. They're subject to lots of different interpretations, and so we can try and apply lots of different conduct to them. And so a defense attorney may raise the argument that we're not doubting what the defendant did, but what the defendant did doesn't fit within the definition of this particular crime. A third way that the defense can challenge the evidence in the case, or the legal basis for the case, is whether or not the statute the defendant was convicted of was actually constitutional. So if this was a case where the defendant perhaps was inciting violence, the defendant may make an argument that it was protected by the First Amendment. That would raise a question about whether the statute was constitutional or not. Appellate courts would begin working through that particular question. So once the defense does appeal, what's that actually going to look like? How is it different from what we've been talking about throughout this entire series about trial courts? Well, we have two different levels of appellate courts, as we've talked about in episode 2. The first is our intermediate trial or appellate court. The second is our Supreme Court. You only have the right to appeal to the intermediate court. The Supreme Court of the state or the United States Supreme Court has discretion over which cases it will hear. Arguments in these cases are going to focus on law. They are law-oriented, as we discussed before. We're not going to argue the facts. We're not going to say there's a question about what one witness said versus what another witness said. Instead, what's going to happen is the attorneys are going to file written statements of their argument. The defense will go first. Because it is an appeal, they no longer have the presumption of innocence. Now they have the burden of proof to show that the appellate court made a mistake or that there was some sort of substantive criminal law problem. As a result, they go first. They will file a written document establishing their argument. After the prosecution receives that argument, they will then respond in written form, and then the defense will have the chance to offer a rebuttal to the prosecution's argument. Once all of these written briefs have been submitted to the court then will set the case for oral argument. Here is only going to be the lawyers. The defendants aren't going to be there. The witnesses aren't going to be there. There's going to be the judges who hear the case and the lawyers, and that's it. The lawyers will stand up. They will present their arguments to the court, and they will be asked questions by the judges. The judges may have certain questions about the law. They may have certain questions about what the facts actually were. And they will respond to those questions throughout the argument. Both sides have an equal amount of time for the argument. So the defense will go first. They will present their first part of their argument. They will sit down. The prosecutor will get up, present the prosecution argument, and then sit down. The defense will have the opportunity again to provide a rebuttal argument as well. Once those oral arguments are completed, the judges are going to retire to consider their verdict. In other words, they're not going to give a decision at that time. In fact, there may be several months to a year that passes before a decision is actually rendered, because rather than give it just orally, saying we find the defendant guilty or not guilty, the judges are going to write a written opinion. That opinion will then be published, and that opinion can then be used as precedent in future cases. As you've noticed, I've said over and over again, judges. There are multiple judges who sit on these cases. Unlike the trial court where there is just one judge, appellate cases have multiple judges. At the intermediate level, there's usually going to be 3 judges that will listen to any given case. When you get to the Supreme Court level, it's going to vary from state to state. Some states may have 5 justices, some states may have 7 justices, some states may have 9 justices or even more. However, you're always going to have an odd number of justices because you want to make sure you don't have a tie in the outcome. What judges are going to do is write opinions that correspond with how they believe the case should be resolved. So there'll be a majority opinion, there'll be a dissenting opinion, there may even be concurring opinions where they concur in the outcome, but the reasoning that they use to get to that outcome may be different than what the majority decided. And so that pretty much wraps up the appellate process. Again, some key differences is it's all about the law. There's no question of facts. There are a lot more judges who are weighing in, and then there's not as many rights that are attached. The defendant is not even present for when these things occur. Now that we have concluded the courts and trials process, we need to circle back to where we started. We have to ask the question, now that we've gone through this entire process, how do we know if we got it right? What happens if we get it wrong? What does it mean to get the case right? What does it mean to get the case wrong? So when we think about what it means to get the case right, we have to go back to some of those initial questions that we looked at on the very first episode. We looked at what is the purpose of our system? What is it that we want to accomplish? If we find the truth, does that mean that we got it right? If we had a fair trial, does that mean we got it right? If the defendant entered a guilty plea, does that mean, well, we must have gotten it right? If the defendant was able to appreciate and to exercise all of his or her particular rights, does that mean that we got the case right? What if we simply provided justice to the victim? Does that mean we got it right? What if justice was done to the defendant? Does that mean we got it right? Suppose all parties agree that justice was done. Does that mean we got it right? Can we even do all of these things on any given case? So in order to figure out what is right and what is wrong, we have to go back to that question, what the court system is all about and why are we here? One potential answer is that we do want to find the truth. We want to find out what happened, at least as best that we can. But as we've seen throughout this series, the people involved in the system, the way the system operates on a day-to-day basis, is not always geared to finding the truth. Instead, the system is geared to winning. The system is geared to moving cases through the process. So maybe in that instance, we never get it right, or at least we get as close as we think we can with the resources that we have allotted. While we may not know what getting it right means, we certainly know what getting it wrong means. And getting it wrong means that someone is found guilty or someone enters a guilty plea when they did not actually commit their crime. They are actually innocent. And over the last 20 years, we've had numerous instances where the scientific process of DNA has exonerated people for very serious crimes. We've had rapes and murders that have been solved through DNA, and when we've solved them, we find, oh, the person convicted isn't actually the person who committed the crime. And so we have to figure out, how do we fix this process? What are the reasons for these wrongful convictions? Right? We can blame the prosecutor, we can blame the defense attorney, we can blame the jury, we can blame science. Right? We can blame the process itself. Right? All of these different pieces factor in together to contribute to these wrongful convictions. And so we have to begin thinking about what changes do we make? If we make a change, is it going to affect something else? Can we really run a system where there are no wrongful convictions? Ultimately, I can propose answers, but you, the member of the public, the person who's going to go work in the system, you have to decide those answers for yourself. You have to decide, as we've taken this journey, where you stand on these issues. And as you begin wrestling and thinking about that, only then will we be able to transfer our system from an illusion of justice to a system where we actually provide justice. Thank you for watching these 9 episodes. Hope you enjoyed them, and always appreciate any feedback you might want to give. Thank you very much.